Protection of interest of minorities. Article 29 provides that any section of the citizens residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. Further, no citizen shall be denied admission into an educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, races, caste, or language. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. This is because of the use of word section of citizen in the article that include minorities as well as majority. The Supreme Court also held that the right to conserve the language includes the right to hesitate for the protection of the language. Hence, the political speech or promises made for the conservation of the language of a section of the citizens does not amount to corrupt practice under the Representation of the People Act 1951. Second, right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. A. All minorities shall have the right to establish and administer educational institution to their choice. B. The compensation amount fixed by the state for the compulsory acquisitions of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities. In this regard, the Act deleted the right to property as a fundamental right, Article 31st. C. In granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens as under Article 29. However, the term minority has not been defined to anywhere in this Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of three types. A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. And C. Institutions that neither seek recognition nor aid from the state. The institution of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff, and so on. The institution of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulations, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College case 2007. The Supreme Court has summarized the general principles relating to establishment and administration of minority educational institutions in the following way. The right of minorities to establish and administer educational institution of their choice comprises the following rights. First, to choose its governing body in whom the founders of the institutions have faith and confidence to conduct and manage the affair of the institution. Second, to appoint teaching staff, teachers, lecturers, and headmasters, principals, as also non-teaching staff, and to take action if there is declarations of duty on the part of any of its employees. Third, to admit eligible students of their choice and to set up a reasonable fee structure. And fourth, to use its properties and assets from the benefit of the institution. Second, the right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minority in a more advantageous position vis-a-vis the majority. There is no reverse discrimination in favor of minorities. The general law of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. applicable to all, will equally apply to minority institutions also. Third, the right to establish and administer educational institution is not absolute, nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administrations as are necessary to ensure that the administration is efficient and sound so as to serve the academic needs of the institution. Regulation made by the state concerning generally the welfare of students and teachers, regulation laying down eligibility criteria and qualification for appointment, as also conditions of service of employees, both teaching and non-teaching, regulation to prevent exploitations or operations of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interfere with the right under Article 31st. Fourth, subject to eligibility conditions, qualifications prescribed by the state being met, the unaided minority educational institutes will have the freedom to appoint teachers, lecturers by adopting any rational procedure of selection. Fifth, extended of aid by the state does not alter the nature and character of the minority educational institutions. The condition can be imposed by the state to ensure proper utilizations of the aid without, however, diluting or abrogating the right under Article 31st. Right to constitutional remedies. A mere declaration of fundamental rights in the Constitution is meaningless, useless, and worthless without providing an effective machinery for their enforcement if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental right of an aggrieved citizen. In other words, the right to get the fundamental rights protected in itself a fundamental right, the makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be unhealthy. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of this Constitution. Hence, it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following four provisions. A. The right to move the Supreme Court by appropriate proceeding for the enforcement of the fundamental right is guaranteed. B. The Supreme Court shall have power to issue direction or orders or writs for the enforcement of any of the fundamental right. The writs issue may include habeas corpus, mandamus, and prohibitions and certiorari and quo warranto. C. Parliament can empower any other court to issue directions, order, and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include high courts because Article 226 has already conferred these powers on the high courts. D. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental right during a national emergency. Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental right of the citizen. It has been vested with the original and wide powers for that purpose. Original because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide because its power is not restricted to issuing of order or directions but also writs of all kinds. The purposes of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive, and summary remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights statutory rights, customary rights, and so on. The violations of a fundamental right is a sine qua non for the exercise of the rights conferred by Article 32. In other words, the Supreme Court under Article 32 cannot determine the questions that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdictions of the Supreme Court is original but not exclusive. It is concurrent with the jurisdictions of the High Court under Article 226. It vests original powers in the High Court to issue directions, order and writs of all kinds for the enforcement of the fundamental right. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Since the right guaranteed by Article 32, the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right. The availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved parties should first move the High Court. Writs, type and scope. The Supreme Court under Article 32 and the High Court under Article 226 can issue the writs of habeas corpus, mandamus, prohibitions, certiorari, and quo warranto. Further, the Parliament under Article 32 can empower any other court to issue these writs since no such provision has been made so far. Only the Supreme Court and the High Courts can issue the writs and not only other courts. Before 1950, only the High Court of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are also so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice. Later, the High Court started issuing these writs and extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of High Court in three respects. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of the fundamental right but also for any other purpose. The expression for any other purpose refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court in this respect is narrower than that of High Court. Second, the Supreme Court can issue writs against a person or government throughout the territory of India, whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction, only if the cause of action arise within its territorial jurisdiction. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. Third, a remedy under Article 32 is in itself a fundamental right, and hence the Supreme Court may not refuse to exercise its writs jurisdiction. On the other hand, a remedy under Article 22-26 is discriminatory, and hence a High Court discriminatory and hence a High Court may refuse to exercise its writs jurisdiction. Article 32 does not merely confer power on the Supreme Court, as Article 226 does, on a High Court to issue writs for the enforcement of fundamental right or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of this fundamental right. Now we will proceed to understand the meaning and scope of different kind of writs mentioned in Article 32 and 226 of the Constitution. Habeas corpus. Habeas corpus It is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examined the causes and legality of detention. It would set the detention person free. If the detention is found to be illegal. Thus, this right is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful. The proceeding is for contempt of a legislature or a court. C. Detention is by a competent court. And D. Detention is outside the jurisdiction of the court. Mandamus. It literally means we command. We command it a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, and an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force. When the duty is discretionary and not mandatory. D. To enforce a contractual obligations. E. Against the President of India or the state governors. And F. Against the Chief Justice of a High Court acting in judicial capacity. Prohibitions. Now we talk prohibitions. Literally, it means to forbid. It is issued by a higher court to a lower court or a tribunal to prevent the latter from exceeding its jurisdictions or and usurping a jurisdiction that it does not possess. Thus, unlike mandamus that directs activities, the prohibitions directs inactivity. The writ of prohibitions can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individual or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. It is issued on the ground of excesses of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting right of individual. Like prohibition, certiorari is also not available against legislative bodies and private individual or bodies. Quo warranto. In the literal sense, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpations of public office by a person. The writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in case of ministerial office or private office, unlike the other four writs. This can be sought by any interested person and not necessarily by the aggrieved person. Armed forces and fundamental rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective of this provision is not ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not on state legislature. Any such law made by Parliament cannot be challenged in any court on the ground of controversies of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act 1950. The Navy Act 1950, the Air Force Act 1950, the Police Forces Restrictions of Rights Act 1966, the Border Security Forces Act, and so on. These impose restrictions on their freedom of speech. Right to form association, right to be members of trade unions or political association, right to communicate with the press, right to attend public meetings or demonstrations, etc. The expression member of the armed forces also covers such employees of the armed forces as the barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors, and are non-combatants. Parliamentary laws enacted under Article 33 can also exclude the court-martial tribunals established under the military law from the writ jurisdiction of the Supreme Court and the High Court so far as the enforcement of fundamental rights is concerned. Marital law and fundamental right. Article 34 provides for the restrictions of the fundamental rights. While marital law is enforced in any area within the territory of India, it empowers the Parliament to indemnify any government service or any other persons for any act done by him in connection with the maintenance or restorations of order in any area where marital law was in force. The Parliament can also validate any sentence passed, punishment inflicted, fury features ordered to other act done under marital law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contraventions of any of the fundamental right. The concept of marital law has been borrowed in India from the English common law. However, the expression marital law has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations, framed outside the ordinary law. It thus implies the suspension of ordinary law and the government by military tribunals. It is a different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare marital law. However, it is implied in Article 34, under where marital law can be declared in any area within the territory of India. The marital law is imposed under the extraordinary circumstances like war, invasion, insurrections, rebellion, riot, or any violent resistance to law. Its justification is to repel force by maintaining or restoring order in the society. During the operations of marital law, the military authorities are vested with abnormal power to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians, and even condemn them to death. The Supreme Court held that the declaration of marital law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a marital law under Article 34 is different from the declaration of a national emergency under Article 352. The differences between the two are summarized affecting certain fundamental rights. Heading New. Article 35 lays down that the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislature. The provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement in this direction. Article 35 contains the following provision. First, the Parliament shall have and the legislature of a state shall not have power to make law with respect to the following matter. A. Prescribing residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. Article 16. B. Empowering court with other than the Supreme Court and the High Court to issue direction, order and writs of all kinds of the enforcement of fundamental right. Article 32. C. Restricting or abrogating the application of fundamental right of a member of armed forces, police forces, etc. Article 33. D. Indemnifying any government servant or any other persons for any act done during the operations of martial law in any area. Article 34. Second, Parliament shall have and the legislature of a state shall not have powers to make law for prescribing punishment for those acts that are declared to be offences under the fundamental right. These include the following: A. Untouchability, Article 17. B. Traffic in human beings and forced labour, Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above act, thus making it obligatory on the part of this Parliament to enact such law. Third, any law in force at the commencement of the Constitution with respect to any of the matter specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends to the competence of the Parliament to make a law on the matter specified above, even though some of those matters may fall within the sphere of the state legislature. Present possession of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19 first if, Article 31st, Article 19 first if guaranteed to every citizen the right to acquire, hold and dispose of property. Article 31st, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. It provided that no provisions shall be deprived of his property except by authority of law. It empowered the state to acquire the requisition the property of a person on 2 conditions. It should be for public purpose, and B. It should provide for payment of compensation amount to the owner. Since the commencement of the Constitution, the fundamental right to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is 1st, 4th, 7th, 25th, 39th, 14th and 42nd Amendment. Through these amendments, Article 31st A, 31st B and 31st C have been added and modified from time to time, nullify the effect to Supreme Court judgment and to protect certain law from being challenged on the ground of contraventions of fundamental rights. Most of the litigation centered around the obligations of the state to pay compensation for acquisitions or requisitions of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19 first if and Article 31st from Part 3rd. Instead, the Act inserted a new Article 300A in Part 12th. Under the heading Right to Property, it provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as a distinct from the fundamental rights, has the following implications. A. It can be regulated, curtailed, abrogated or modified without constitutional amendment by an ordinary law of the Parliament. B. It protects private property against executive actions but not against legislative actions. C. In case of violation, the aggrieved persons cannot directly move the Supreme Court under Article 32 right to constitutional remedies including writs. For its enforcement, he can move the High Court under Article 226. D. No guaranteed right to compensation in case of acquisitions or requisitions of the private property by the state. Though the fundamental right to property under Part 3rd has been abolished, the Part 3rd still carries 2 provisions which provides for the guarantee right to compensation in case of acquisition or requisitions of the private party property by the state. These 2 cases where compensation has to be paid are: A. When the state acquires the property of a minority educational institutions, Article 30, and B. When the state acquires the land held by a person under his personal cultivations and the land is within the statutory ceiling limits, Article 31st. The first provision was added by the 44th Amendment Act 1978, while the second provision was added by the 17th Amendment Act 1964. Further, Articles 31st A, 31st B and 31st C have been retained and exceptions to the fundamental rights.